Yo. Always check description for more details. Leading questions to a child witness. As to a child witness, Sec. 10, Rule 132 of the Rules of Court should be deemed modified by Sec. 20 of the Rule on Examination of a Child Witness. Under the said rule, the court may allow leading questions in all stages of examination of a child under the condition that the same will further the interest of justice. Under the rules of court, a leading question may be asked of a child only if there is difficulty of eliciting from said child a direct and intelligible answer. Sec. 10 C. Rule 132, Rules of Court. Illustrations. The following examples of leading questions in a direct examination may be illuminating. Illustration number 1. The case is a collection case. The defendant contends that the debt has been paid. He calls a witness to testify to the fact of payment. Q. While the plaintiff and the defendant were engaged in a conversation on the date and time you mentioned, did you see the defendant deliver P50 OO to the plaintiff? The question is objectionable on the ground that it is leading. Here, the examiner obviously wants the witness to directly testify that money was delivered by the defendant to the plaintiff in his presence. The question could have been properly framed in this manner: what have you observed, if any, while the plaintiff and the defendant were engaged in a conversation? Illustration number 2. The fact situation is a robbery case. The accused claims innocence and that a couple of hours after the alleged robbery, he is arrested by the police while in the park with his children. The defense counsel calls the accused to the stand. What were you doing in the park? I was taking a stroll with my 2 adolescent children. While you were in the park with your children, the police officers arrived to arrest you, is that true? The question is leading. It suggests the next event which the witness should testify to. The attorney could convert the question into a non-leading one by taking the suggestive element out of the question. Thus, what happened, if any, while you and your children were in the park? Misleading questions. 1. A misleading question is one which assumes as true a fact not yet testified to by the witness, or contrary to that which he has previously stated. It is not allowed, Sec. 10 Rule 132, Rules of Court, in any type of examination. 2. Consider this illustration. Counsel, you testified that you and the accused were in a car bound for Baguio City. How fast were you driving? This question is objectionable as misleading where there was no previous testimony from the witness that he was driving the car. The question assumes a fact not yet in evidence. D. Impeachment of a witness. 1. Impeachment is basically a technique employed usually as part of the cross-examination to discredit a witness by attacking his credibility. Destroying credibility is vital because it is linked with a witness' ability and willingness to tell the truth. 2. The rules enumerate certain guideposts in impeaching a witness. A. The impeachment of a witness is to be done by the party against whom the witness is called. Sec. 11 Rule 132, Rules of Court. B. Subject to certain exceptions, the party producing the witness is barred from impeaching his own witness. Sec. 12, Ibid. Thus, if D calls W as his witness, D is not allowed to impeach the credibility of W. It is the adverse party, P, against whom W was called, who is AC courted the privilege of impeaching W, C, by way of exception to the immediately preceding rule. If the witness is unwilling or hostile, the party calling him may be allowed by the court to impeach the witness. But it is not for the party calling the witness to make a determination that the witness is unwilling or hostile. Whether or not a witness is hostile is addressed to judicial evaluation, and the declaration shall be made only if the court is satisfied that the witness possesses an interest adverse to the party calling him, or there is adequate showing that the reluctance of the witness is unjustified, or that he misled the party into calling him as a witness. Sec. 12, Ibid. A party may also be allowed to impeach his own witness when said witness is an adverse party or is an officer, director, or managing agent of a corporation, partnership or association which is an adverse party. Sec. 12, Ibid. D. It is also improper for the party calling the witness to present evidence of the good character of his own witness. The same is allowed only if the character of the witness has been impeached. Sec. 14, Ibid. Thus, evidence of the good character of the witness is allowed only to rebut the evidence offered to impeach the witness' character. If he has been impeached, then he can be rehabilitated by evidence of his good character. How to impeach a witness. 1. Sec. 11 of Rule 132 specifies the manner of impeaching the witness of the adverse party. It declares, Sec. 11. Impeachment of adverse party's witness. A witness may be impeached by the party against whom he was called, by contradictory evidence, by evidence that his general reputation for truth, honesty, or integrity is bad, or by evidence that he has made at other times statements inconsistent with his present testimony, but not by evidence of particular wrongful acts, except that it may be shown by the examination of the witness, or the record of the judgment, that he has been convicted of an offense. 2. Under the above rule, a witness may be impeached through the following modes. A. By contradictory evidence, b. By evidence that his general reputation for truth, honesty or integrity is bad, or c. By evidence that he has made at other times statements inconsistent with his present testimony, sec. 11 Rule 132, Rules of Court. 3. A witness cannot be impeached by evidence of particular wrongful acts except evidence of his conviction of an offense as disclosed by his examination or the record of the judgment, sec. Ill, ibid. 4. An unwilling or hostile witness so declared by the court or the witness who is an adverse party cannot be impeached by evidence of his bad character, sec. 12, ibid. Impeachment by contradictory evidence. Every ethical trial lawyer will tell us that one basic rule in impeaching a witness by contradictory evidence is the observance of fairness. Fairness demands that the impeaching matter be raised in the cross-examination of the witness sought to be impeached by allowing him to admit or deny a matter to be used as the basis for impeachment by contradictory evidence. Normally, the basis of this mode of impeachment is a declaration made by the witness in his direct testimony. The cross-examiner's intention is to show to the court that there were allegations made by the witness that do not correspond to the real facts of the case. This mode of impeachment may also be used to contradict conclusions made by expert witnesses during their testimonies. Usually, the adverse party may also call another expert to testify to a contrary conclusion. Illustration: witness A testifies on direct examination that he was barely 5 meters away from where the accused, D, shot the victim. V. The defense counsel has reliable information that, at the time the shooting took place, witness A was standing as a witness in a wedding of his friend, witness B, in a place 100 miles away. The defense counsel now asks, "You testified that you were present when D shot V, is that right?" "Perfectly right, sir." "Isn't it true that, at the time of the alleged shooting of V by D, you were in a wedding of your friend miles and miles away?" "That isn't true, sir." "Absolutely not." Because witness A denied his being in a friend's wedding at the time of the incident, the defense counsel now has the chance to prove the contrary by a contradictory evidence. He can do so by calling witness B or any other witness to testify on the whereabouts of witness A on the relevant date and impeachment by prior inconsistent statements. 1. Prior inconsistent statements are statements made by a witness on an earlier occasion which contradict the statements he later made during the trial. In the words of Sec. 13 of Rule 132, they are that he has made at other times statements inconsistent with his present testimony. These inconsistent statements are admissible to impeach the credibility of the witness making them. Impeachment by a prior inconsistent statement is the most commonly used method because of its simplicity and the impact it makes when properly used, the relevant rule provides. Sec. 13. How witness impeached by evidence of inconsistent statements. Before a witness can be impeached by evidence that he has made at other times statements inconsistent with his present testimony, the statements must be related to him, with the circumstances of the times and places and the persons present, and he must be asked whether he made such statements, and if so, allowed to explain them. If the statements be in writing, they must be shown to the witness before any question is put to him concerning them. 2. Effectively impeaching a witness by prior inconsistent statements requires laying the proper foundation for the impeachment. Laying the foundation, commonly referred to as laying the predicate, is a preliminary requirement before the impeachment process prospers. The elements of this foundation are clearly spelled out in Sec. 13 of Rule 132. These are: A. The alleged statements must be related to the witness including the circumstances of the times and places and the persons present. If the statements are in writing, they must be shown to him, and B. He must be asked whether he made such statements and also to explain them if he admits making those statements. 3. The mere presentation of the prior declarations of the witness without the same having been read to him while Testifying in court is insufficient for the desired impeachment of his testimony, if he was not given the ample opportunity to explain the supposed discrepancy, not only upon common sense, but is essential to protect the character of the witness. People v. de Guzman, 288 SCRA 346, 354. 4. To achieve a dramatic effect, the first step in setting up the prior inconsistent statement would actually be to ask the witness to repeat or reaffirm his most recent statement. The second step would be to relate to the witness his prior inconsistent statement and, at the same time, building up, or highlighting the contradictory utterance by relating to the witness the circumstances of times, persons and places. Then, the witness is asked whether or not the statements were made. See Sec. 13 Rule 132, Rules of Court. The underlying purpose for laying the predicate is to allow the witness to admit or deny the prior statement and afford him an opportunity to explain the same. Non-compliance with the foundational elements for this mode of impeachment will be a ground for an objection based on improper impeachment. Over a timely objection, extrinsic evidence of a prior inconsistent statement without the required foundation is not admissible. Illustration number 1, the case is a robbery case. The accused has Oriental features and is 5 feet and 3 inches tall. The prosecution witness is one who allegedly saw the culprit come out of the crime scene. Mr. A, you testified on direct examination that the man you saw come out of the burglarized store had Oriental features and was a little over 5 feet tall. Is that correct? Yes, sir. Are you certain of your description of the man? Very certain, sir. And when was this? On February 15, 2015, around 9:30 in the evening. That was the date and time of the burglary. Do you recall having seen SPO4 Morales outside the burglarized store at around 10 o'clock of the same day and night? I do, sir. He spoke to me that night and asked me what I saw. And that was only 30 minutes from the time you saw the man, is that correct? That is correct, sir. And at that time, everything was still fresh in your mind. Right? You're absolutely right, sir. Do you recall telling SPO4 Morales that you cannot give an accurate description of the man who came out of the burglarized store because he was wearing a bonnet over his face, had a pair of gloves on and was wearing dark long sleeves? At this point, the witness gets boxed in, and his credibility starts crumbling no matter how he responds to the question asking him to affirm or deny the prior inconsistent statement. If the witness admits the prior inconsistent statement, the rule requires that he be allowed to explain them. Often, it is difficult to explain inconsistent statements and would require a lot of effort. If the witness denies making the statement, it is imperative for the impeaching party to be prepared to present another witness who would contradict the witness being impeached. It happens sometimes that the prior inconsistent statement is in writing. The process of laying the predicate is fundamentally the same as when the prior statement is oral. But if the statement be in writing, it must be shown to the witness before any question is put to him concerning it. Sec. 13 Rule 132, Rules of Court. Illustration number 2, the case is one for murder. The witness was interviewed by the police 10 minutes after the incident. In her signed statement, she claimed that she did not actually see the accused fire the shot that killed the victim, but in her direct examination, she testified that she saw him fire once at the victim. Did you earlier testify that you saw the accused fire at the victim? I did, sir. Are you certain of that? Yes, sir. Do you recall having made a statement to the police 10 minutes after the incident? Yes, sir, I made it before Detective Rosales. Your statement was reduced to writing, is that right? Right, sir. After your statement was typed, it was shown to you, right? Yes, sir. He asked you to read the statement very carefully before you signed it. Am I correct? Yes, sir. After making sure that the contents of the written statement were correct, you signed the statement. Is that correct? That is correct, sir. I am showing you a 3-page statement entitled Sinumpang Salese. Is this the statement you signed before Detective Rosales? It is, sir. At the end of the last page is a name and signature over the name. Is that your name and signature? They are, sir. Counsel will now ask that the statement be marked as an exhibit including the name and signature of witness, then counsel will call the attention of the witness to the relevant paragraph of her signed statement. The reading of the prior inconsistent statement must be verbatim, not a mere summary, as, in paragraph 13 of this Sinumpang Salese, you stated, and I quote, "Impeachment by showing bad reputation." 1. When a witness testifies, he puts his credibility at issue because the weight of his testimony depends upon his credibility. One way to impair his credibility is by showing a not-so-pleasing reputation, hence, the prevailing rule allows his impeachment by evidence that he has a bad general reputation. 2. Not every aspect of a person's reputation may be the subject of impeachment. Evidence of bad reputation for the purpose of impeachment should refer only to the following specific aspects. A. For truth, B. For honesty, or C. For integrity, sec. 11 Rule 132, Rules of Court. These are aspects of a person's reputation that are relevant to his credibility. He cannot be impeached for his reputation on other grounds. Thus, it would be improper for a witness to be impeached because of his reputation for being troublesome and abrasive. Example, Mr. W is called by the prosecution to testify that it was indeed the accused who picked the pocket of the victim when the latter accidentally tripped by the sidewalk. The defense later presents Mr. D, a neighbor of for 30 years, who testifies that Mr. W has a reputation in the community for telling lies. The testimony of Mr. D is an impeaching testimony to discredit Mr. W. Mr. D, who has testified on the reputation of Mr. W, may be cross-examined like any witness. He may be asked on cross-examination about the extent of his familiarity with the witness who is being impeached, together with any prejudice and biases he may have against the witness or his stake and interest in the case. No impeachment by evidence of bad character but by bad reputation. 1. It should be noted that Sec. 11 does not allow impeachment by evidence of bad character but by bad reputation. 2. Character is made up of the things an individual actually is and does, whereas reputation is what people think an individual is and what they say about him. McNulty v. State, 138 Texo Cr. R. 03170-135 SW02 D 987, 989, James v. State ex rel. Loser, 2410. App. 453, 145 Sow. 2D 1026, 1033 cited in Black's Law Dictionary, p. 1172. Hence, a person's reputation is not necessarily his character and vice versa. Evidence of good character of the witness. 1. Be it noted, 2, that the party calling a witness cannot initiate proof of his good character. Thus, if the plaintiff in a civil case presents Mr. W to testify on a vehicular collision, the counsel is not allowed to ask questions tending to show the good character or reputation of the witness. Any question to that effect can be validly objected to as improper character evidence. Because a witness is presumed to be truthful and of good character, the party presenting him does not have to prove he is good because he is presumed to be one. It is only after his character has been attacked can he prove his being good. He must first be discredited before his reputation or character can be bolstered. This basic procedural rule is supported by the provisions of Sec. 14 of Rule 132. SEC. 14b Evidence of good character of witness. Evidence of the good character of a witness is not admissible until such character has been impeached. 2. The rule that bars evidence of the good character of the witness, who has not yet been impeached, has reference only to a mere witness. It does not refer to an accused in a criminal case. In a criminal case, the accused may prove his good moral character relevant to the offense charged even before his character is attacked. Sec. Rule 130, Rules of Court. However, the prosecution cannot initiate proof of the bad character of the accused, it can only do so by way of rebuttal. Sec. Ibid. This means that the prosecution can prove the bad character of the accused only if the latter had first presented evidence of his good character. No impeachment by evidence of particular wrongful acts. 1. Consider this example, the case is a criminal prosecution for robbery. The defense is presenting its evidence in chief and calls its first witness to impeach the primary witness of the prosecution. The defense counsel asks a series of questions to show specific instances of misconduct of the prosecution witness. Do you know the prosecution witness? I do, sir. How did you come to know him? 2 years ago, he robbed me of my wallet at gunpoint. Was that incident the first time you came to know the prosecution witness? No, sir. Prior to my being robbed by him, he stole the carabao of my neighbor. Is this line of questioning objectionable? Certainly, it is. A witness cannot be impeached by evidence of particular wrongful acts. Sec. 11 Rule 132, Rules of Court. He can, nevertheless, be impeached as to his bad reputation for truth, honesty or integrity. Thus, how long have you known the prosecution witness? Since childhood, sir. How well do you know him? Very well, sir. Why do you say so? We studied in the same school since nursery school until we both graduated from college. We were also neighbors since childhood. What can you say about his reputation? Terrible, sir. He is reputed to be dishonest and untruthful. This line of questioning does not violate the rules on impeachment. This is not an impeachment by evidence of specific wrongful conduct which is barred, but an impeachment by evidence of bad reputation. 2. As earlier mentioned, Sec. 11 of Rule 132 disallows the impeachment of a witness by evidence of his particular wrongful acts. There is, however, a particular wrongful act that is admissible in evidence under the same section, his prior conviction of an offense. This prior conviction of the witness is shown through either of two ways. A. By his examination, by cross-examining him, or B. By presenting the record of his prior conviction. Examining another witness to elicit from his lips the prior conviction of another witness is not the correct procedure, unless the witness is one who is competent, like an official custodian of records, to present in court the record of conviction. The rule is clear on this. It should be by the examination of the witness. This witness is obviously the one whose prior conviction is the subject of inquiry. Exclusion and separation of witnesses. 1. The judge may exclude a witness who, at the time of exclusion, is not under examination so that he may not hear the testimony of other witnesses. Sec. 15 Rule 132, Rules of Court. 2. The judge may cause the witnesses to be kept separate and be prevented from conversing with one another until all shall have been examined. Ibid. When the witness may refer to a memorandum. 1. During his testimony, in order to refresh his memory, a witness may refer to a memorandum or to anything written or recorded by himself, or written or recorded by someone acting under his direction. Such memorandum should be written at the time the fact occurred or immediately thereafter or at any time when the event or fact was fresh in his memory. It is necessary too that the witness affirm that the fact was correctly written or recorded. Also, the memorandum must be produced and may be inspected by the adverse party. Sec. 16 Rule 132, Rules of Court. 2. The witness may testify from the memorandum, writing or record, although he has no more recollection of the facts written therein as long as he swears that the memorandum writing or record correctly stated the fact or transaction when the recording was made. This type of evidence must, however, be received with caution. Ibid. See you next slide. Thank you.